the Office of the Solicitor General. We recognize the Honorable Menardo Guevarra, sir.
Good morning, Your Honors. I do not have any opening statement to make. I'm here to answer any questions that the members of the two committees may ask in connection with the ICC decision and on the issue of whether we have any legal duty to cooperate with the ICC prosecutor. First of all, Your Honors, I believe that the matter of whether we should cooperate with the ICC prosecutor is a political decision. And in that respect, the head of the Republic, the head of state, the president himself, has repeatedly declared that the Republic cannot extend its cooperation to the ICC in any form or manner whatsoever because national institutions are functioning, which can actually do the investigation and prosecution here, and that any intervention by a foreign entity such as the ICC would be an encroachment on our sovereignty. So that is the political aspect with respect to this matter. But as Solicitor General and Counsel for the Republic, I am here to explain the legal basis on why there is no legal duty on the part of the Philippines to cooperate with the ICC. I will do so on the basis of a major distinction between the existence of jurisdiction and the exercise of that jurisdiction. Jurisdiction over the subject matter, Your Honors, is covered by Article 5 of the Rome Statute. That is jurisdiction over the subject matter, namely over crimes of genocide, crimes of aggression, crimes against humanity, and so forth and so on. Jurisdiction over the subject matter. And there is no doubt, as the Supreme Court pointed out, that the ICC has jurisdiction over offenses or crimes that happened during the time when the Philippines was still a member of the ICC. No question about that. However, the exercise of that jurisdiction is covered by a different section of the Rome Statute. Exercise of jurisdiction is covered by rules, Articles 12 and 13 of the Rome Statute. And there are preconditions to the exercise of jurisdiction by the ICC. Most important of these preconditions for the exercise of jurisdiction is that the Philippines should still be a member of the ICC at the time that the exercise of that jurisdiction is triggered. All right, so when was the exercise of that jurisdiction triggered? It was triggered when the ICC prosecutor requested the ICC chamber, the pretrial chamber, to initiate or to commence an investigation. When did that happen? That request to commence an investigation, which should have triggered the exercise of the ICC's jurisdiction, happened in May of 2021. And the pretrial chamber granted that authorization to commence the investigation in September of 2021. Now, was the Republic of the Philippines still a state party to the ICC at the time that the exercise of jurisdiction was triggered? The Philippines served notice of its withdrawal in March of 2018, and it became effective 1 year later in March of 2019. So at the time that the exercise of jurisdiction was triggered, a precondition for the exercise of that jurisdiction was not existent. And what is that precondition? As I said, membership of the Philippines in the ICC. 2 years had already elapsed when the exercise of jurisdiction was triggered. So for that reason, Your Honors, while in fact it is admitted that the ICC had jurisdiction over the offenses committed during that period when we were still a member, quite unfortunately, the trigger for the exercise of that jurisdiction came much too late. And the ICC prosecutor himself should be, well, I wouldn't want to say blamed, but it's his lack of assiduousness that prompted this situation. This is far different from the case of the Republic of Burundi, because in that case of Republic versus Burundi, Burundi also withdrew from the ICC. But before the 1 year period could elapse, the ICC prosecutor commenced his investigation by asking the pretrial chamber for authorization, and the pretrial chamber granted that authorization. So before that 1 year period expired in Burundi, na-trigger yung exercise of jurisdiction. Not so in the case of the Philippines. So yun po yung legal basis. Baka po tanongin nyo, ano ba yung significance noong 1 year period? Bakit merong 1 year period? The reason for that, Your Honors, is the ICC in the articles, under the articles of the Rome Statute, wanted to balance yun pong two competing interests. One major interest is yung sovereign right of any member state to withdraw from the treaty kung kailan niya gusto. That is one major consideration. Any member, any state, if it doesn't want to continue its membership, it has the sovereign right to withdraw from that membership, what is the other competing interest? The other competing interest is the ICC also wants to make sure that efforts to end impunity are also addressed. So how do you balance these two competing interests? By imposing that 1-year period within which the ICC prosecutor may initiate his investigation before the effectivity of the withdrawal of that state. Yun po yung balancing factor, that 1-year period. But in this case po, ang nangyari, nag-take effect na po yung ating withdrawal in March of 2019, and yet, nung 2021 lang, more than 2 years later, nung nag-trigger ng exercise of jurisdiction. Kasi hindi naman po pwedeng forever, perpetually nakatutok sa atin ang ICC kahit na hindi na po tayo membro ng ICC. Yun po ang paliwanag kung bakit there is no legal duty on the part of the Philippine government to cooperate. As I said, it's a political decision. But from a legal standpoint, the president has made it a point, has emphasized that we have no legal duty to cooperate. Now, the other major consideration po is on the issue of admissibility or the principle of complementarity, which says na ang may primary jurisdiction to investigate all offenses and crimes that happened within Philippine territory belong to the national domestic institutions. At kung hindi po nagpa-function like some rogue states, I wouldn't say in what continent or what, then that's the time that the ICC should enter. Pero hindi naman po tayo nasa category ng isang rogue state. We have a functioning legal system. We have a functioning judicial system. So while it may not be perfect, what we have been emphasizing is it's there, it's in place, it's working. We all know that. Kung may problema sa hustisya, we still go to our national institutions, whether we belong to a political party or not. Pag may problema po tayo, we still go to the Department of Justice. We still go to the PNP kung meron po tayong complaint. We still go to the courts kung meron po tayong any civil matter that needs to be resolved. So we all know that our domestic system, legal system, is still functioning. So yun po yung punto ng presidente from a political standpoint. If we allow someone else to do what we ought to do, then in effect, we're surrendering part of our sovereignty. So by so doing, are we also parang not upholding the rule of law? Not really. Because if we do so by ourselves, using our own national institutions, that is also upholding the rule of law. For now, that's all that I can say, Mr. Chair, and I'm willing to answer any questions that the members of the committees may ask to clarify. Thank you, Your Honor.
Thank you, SolGen Guevarra. We would like now to recognize the representative of the Department of Justice, DOJ.
Pleasant morning to this August body, Mr. Chair. Thank you for acknowledging the presence of the Department of Justice. I am Prosecutor Hazel Decena Valdez, Your Honor. I am the Program Director of the Department of Justice Human Rights Office. And sa tingin ko po, malinaw na nailatag ni SolGen Guevarra ang arguments, ang position ng Executive Department, and specifically the Department of Justice main office is of course echoing the positions as articulated by SolGen, by the Solicitor General. In addition to those, the Department of Justice would like to express the respect to the expression of the sense of the House of Representatives, urging the Philippine government to cooperate through the House resolutions that were filed and are pending consideration right now. Aside from echoing and reiterating the pronouncements made by the President on this matter, the Department of Justice would like to emphasize on the following. Number one, that the present administration has followed through on the efforts of the interagency review panel that was previously created to look into the drug-related operations under the previous administration where death occurred. More particularly, Mr. Chair and Your Honors, Secretary Boying Remulla convened in the past months the Department of Justice, National Prosecution Service, the Philippine National Police, the National Bureau of Investigation, the Philippine Drug Enforcement Agency, including the Dangerous Drugs Board, and gave them clear instructions to ensure that people are made accountable for the wrongs done under the previous administration's campaign on the war on drugs. In Secretary Remulla's words, he does not want for history to remember us as a government that did not do something about that. And thus, these agencies have been looking into more than 7,000 incidents or police operations that resulted in death. The Department of Justice's new policy on the proactive involvement of prosecutors in the investigation of crimes and buildup of cases will give this review of incidents a new perspective, and that is the prosecutors' leadership and supervision of these investigations. With prosecutors closely working with law enforcers in this review and investigation processes, there will be more thorough dissection of the events and evidence involved in these incidents. Secondly, The present administration renewed and continues with its active and constructive engagement with the international community and with the review mechanisms of the United Nations and special mandate holders in order to improve and strengthen the state's accountability mechanisms. For instance, the state engaged in several revalida or constructive dialogues before the United Nations bodies to review, report, and receive recommendations on the state's compliance with several human rights treaties and conventions. Among others, in November 2022, the state engaged with the United Nations Human Rights Council in reviewing compliance with the 8 human rights conventions to which the state is a signatory. And during the Universal Periodic Review, the state accepted no less than 215 out of 289 recommendations from these member states. Incidentally, however, the state took note of the common recommendation from 8 member states of the Council for the Philippines to rejoin the Rome Statute, which established the ICC. The state also engaged with UN committees in reviewing our compliance with our obligations under the following conventions, among others, the Convention on the Rights of the Child, Convention on the Elimination of Racial Discrimination, and the Convention on the Civil and Political Rights. Third, the state also accepted visits of special rapporteurs of the United Nations on climate change, on the sale and exploitation of children, on freedom of expression. Next week, the state will receive the country visit of the UN Subcommittee on the Prevention of Torture, which will examine our compliance with our obligations under United Nations UN Convention Against Torture and the Optional Protocol. And finally, the government, through the Department of Justice and the Department of Foreign Affairs, is working closely with the United Nations under United Nations Joint Program on Human Rights to focus on capacity building to improve on the human rights situation in the Philippines. As a matter of fact, one technical working group is specifically devoted to strengthen our domestic accountability mechanism. And for the past couple of years that the United Nations Joint Program on Human Rights is being implemented, especially in the past several months, the TWG has been engaged in extensive capacity building of duty bearers on with the expectation that by the end of the program and to continue on, the duty bearers will be the capacity of these duty bearers are strengthened. So in fine, Mr. Chair, the Department of Justice wishes to echo the statement of the President that the state's legal, law enforcement, and judicial systems are all working, and thus, and coupled with the recent developments in terms of the efforts of the present dispensation showing the seriousness, sincerity, and willingness of the Philippine government to investigate and prosecute grave international crimes, there is no need for the ICC to step in and dictate on our authorities on, as the President has said, who to investigate, what to investigate, who to arrest, who to detain, and things like that. Finally, echoing the statement of the President that he will continue to defend the sovereignty of the state and will question the jurisdiction of the ICC and their investigations here in the Philippines. He also specifically mentioned that the country's law enforcement and investigative agencies, as mentioned a while ago in the efforts of the government, we are highly capable and can very well handle any probe on the previous administrations or even present or future administration efforts against illegal drugs. Thank you very much, Mr. Chair.
Thank you, DOJ. May we now call on the representative of the Department of Foreign Affairs?
Good morning, Mr. Chair. I'm Acting Director Jenny Sanchez Rivera from the Department of Foreign Affairs, Office of the United Nations and International Organizations. The DFA is a conduit of information from the International Criminal Court through our embassy in The Hague. In view of the government transition, DFA is closely coordinating with lead agencies such as the DOJ and the OSG on this matter and support the DOJ and OSG's views on the issue of ICC investigation. The DFA wishes to note that the Philippine government affirms its commitment to fight impunity for atrocity crimes, notwithstanding the country's withdrawal from the Rome Statute, especially since the Philippines has a national legislation punishing atrocity crimes. The Philippines underscores that it has a primary jurisdiction to investigate and prosecute a crime against humanity allegedly being committed in the context of the anti-illegal drugs campaign. Republic Act number 9851, or the Philippine Act on Crimes Against International Humanitarian Law, genocide and other crimes against humanity punishes criminal conduct covered by the Rome Statute. As a court of last resort, the ICC complements but does not replace national courts. It only operates in cases where national jurisdictions are unable or unwilling to prosecute. Under the Rome Statute, the primary jurisdiction belongs to the state, and the Philippines had passed Republic Act 9851 before it ratified the Rome Statute. Further, the Philippine Constitution espouses generally accepted principles of international law. That would be all, Mr. Chair. Thank you.
Thank you. Now I'd like to call on the Commission on Human Rights, please. Commissioner Faida Dumarpa.
Assalamualaikum, Your Honors. I am Faida Maniri Dumarpa, one of the members of the Commission on Bank of the Commission on Human Rights, and today I represent the Commission in today's proceedings. Allow me to share, Your Honors, that the Philippines has signed almost all human rights treaties and that our country has historically been at the forefront of advancing rule of law and international justice. No less than His Excellency President Bongbong Marcos has pledged and guaranteed that human rights would be protected during his term. The CHR, as the National Human Rights Institution of the Republic of the Philippines, and mandated to protect and promote the human rights of every Filipino, we are of the position that that the Commission will cooperate if the ICC so requests, and the extent of our cooperation would be determined in accordance with the specific request of the ICC and within the mandate of the Commission on Human Rights. Thank you very much.
All right, thank you. We have the Center for International Law, Attorney Gilbert Andres, the Executive Director. You recognize, please?
Good morning, Mr. Chairs, and good morning, Your Honors. Your Honors, it's the position of the Center for International Law that we should cooperate with the ICC, and we urge the approval of the 3 House resolutions on 6 grounds. In fact, Your Honor, I will not start with public international law. I will start with Philippine domestic law, because in fact, this honorable House, together with the Senate, passed in 2009, RA 9851. What is RA 9851? It's the Philippine Act on Crimes Against International Humanitarian Law, Genocide, and Other Crimes Against Humanity. It was signed into law on December 11, 2009. In fact, Your Honor, what was the context? Why is it that this honorable House and the Senate passed 9851? Because at that time, we signed the Rome Statute, but we were not a state party to the Rome Statute, because the President did not send the ratified Rome Statute to the Senate. Hence, there was actually an advocacy campaign for the Philippines to satisfy its international obligation under international humanitarian law, under the Geneva Conventions. And we have ratified all of the Geneva Conventions. Hence, Your Honors, your Congress passed RA 9851. And what does RA 9851 provide? Your Honors, I want to refer you to Section 17 of RA 9851, because it actually provides for the reverse complementarity principle. And I will read it, Your Honor, and I want to place it on the record, that relevant portion of Section 17. And I quote, "In the interest of justice, the relevant Philippine authorities may dispense with the investigation or prosecution of a crime punishable under this act if another court or international tribunal is already conducting the investigation or undertaking the prosecution of such crime. Instead, the authorities may surrender or extradite suspected or accused persons in the Philippines to the appropriate international court, if any, or to another state, pursuant to the applicable extradition law and treaties." Hence, Your Honor, what is actually provided in Section 17 of RA 9851 is reverse complementarity. In fact, the Philippine authorities may just opt to just surrender an accused person before an international tribunal, such as the ICC. And Your Honors, in Senator Pangilinan versus Cayetano, the Supreme Court actually referred to this principle of reverse complementarity. How do I know? I was actually, Your Honors, a petitioner and a counsel in that petition, PCICC versus Executive Secretary. Hence, Your Honor, it's actually an exercise of sovereignty for the Philippines to cooperate with the ICC, because it's provided for under Section 17 of RA 9851. Your Honor, our second point is important, especially in the context of the West Philippine Sea dispute. Our Philippine Coast Guard, our Filipino fishermen, they have been harassed by the Coast Guard or by the militia of a certain state in the north, a powerful state. And what have we been invoking always? We have been always invoking international law and compliance with a rule-based international legal order. In fact, Your Honor, the arbitral award that was decided on July 12, 2016, Philippines versus China, it's based on international law, the UN Convention on the Law of the Seas. And it's a historical fact that China does not recognize the jurisdiction of the arbitral body. China does not recognize the arbitral award. And yet it does not invalidate the arbitral award that we have won, and which we have won not just for the Philippines, but for the region in Southeast Asia. Because we say that we should adhere to international law and a rules-based international legal order. Hence, Your Honor, if we be faithful with that consistent plea of the Philippines for international law, we should also be consistent with our international obligation under the ICC Rome Statute, which leads to our third point. Your Honor, the Philippines was actually part of the delegation of plenipotentiaries in the ICC Rome Conference in June or July of 1998. We actually sent a delegation to actually participate in the drafting. And we were actually very active in the drafting of the ICC Rome Statute. In fact, Your Honor, we signed it in December of 2000, except it was not passed for concurrence by the Senate. And when it was signed, it was actually ratified by the President. It was sent to the Philippine Senate for its concurrence. And in fact, during the deliberations before the subcommittee, then chaired by Senator Miriam Defensor Santiago, agencies of the government actually supported the concurrence of the ratification. What agencies were these? These were the DOJ, the DFA, the Philippine National Police, the Armed Forces of the Philippines, the Commission on Human Rights. They actually approved and supported concurrence into the ICC Rome Statute. And Your Honor, on August 23, 2011, the Philippine Senate, on a vote of 17-1, passed, concurred into the ICC Rome Statute. And you can see from the records who were one of the 17 senators. It was then Senator Ferdinand Romualdez Marcos Jr. Yes, he voted for the approval, the concurrence of the Rome Statute ratification. And Your Honor, it's presumed that legislators actually do their official business in good faith. All the drafts, all the bills, all the resolutions that you are actually voting upon. And Your Honor, in fact, if we were a state party to the ICC, it means that we are obligated under the ICC. And in fact, there's actually a residual obligation, even though we withdrew. It's in Article 127 of the ICC Rome Statute. And I want to refer Your Honors to Article 127. In fact, it's an important article because it's precisely the article that the Philippines invoke in order to withdraw. That's paragraph 1. But in paragraph 2 of Article 127, it provides for a residual obligation. And I want to quote that verbatim in paragraph 2. And I quote, "A state shall not be discharged by reason of its withdrawal from the obligations arising from the statute, while it was a party to the statute, including any financial obligations which may have accrued. Its withdrawal shall not affect any cooperation with the court in connection with criminal investigation and proceedings in relation to which the withdrawing state had a duty to cooperate and which were commenced prior to the date on which the withdrawal became effective. Nor shall it prejudice in any way the continued consideration of any matter which was already under consideration by the court prior to the date on which the withdrawal became effective." And Your Honor, in Pangilinan versus Cayetano, the Supreme Court referred to Article 127 of the ICC Rome Statute, and even it actually affirmed our residual obligation under that provision. In fact, it says that we really have to cooperate based on Article 127, paragraph 2 of the ICC Rome Statute. Which leads, Your Honor, to my fourth point. Your Honor, complementarity has always been said to be a provision wherein the ICC will come in if the state is unwilling or unable. Your Honor, to be honest and to be frank, with all due respect, that's actually a misconception. Why? Because if you want to look at complementarity as a principle, you have to look at Article 17 of the ICC Rome Statute. And Article 17 of the ICC Rome Statute has 3 paragraphs. 1, 2, 3. This is the architecture. Paragraph 1 refers to any situation, any cases that are not admissible before the ICC. And what are these cases which are not admissible to the ICC? These are cases wherein an investigation or a prosecution has been done, okay, except the state is unwilling or unable to genuinely prosecute or investigate. Meaning to say, Your Honor, if you just look at the grammar, the text itself, it presupposes that there's an investigation or a prosecution for international crimes. Now, if there's an investigation or prosecution, then the ICC will look, is this investigation or prosecution, is it really genuine? Or the state is unwilling or unable to genuinely, and I'm saying that, genuinely, to emphasize, investigate or prosecute. Hence, Your Honors, it means that if the state is not actually investigating or prosecuting, then that's the time that the court, the ICC, will do its complementary jurisdiction. Why? Because the state did not do its primary jurisdiction to investigate international crimes. And the context here, Your Honors, these are not just simple crimes. These are most serious crimes of concern to the international community. In fact, these are international crimes, war crimes, genocide, crimes against humanity. And we had that experience, Your Honors, during the Japanese occupation. 100,000 Filipinos were murdered, looted, raped, burned in Manila from Feb 3 of 1945 up to March 3 of 1945. 100,000 Filipinos. And that's a war crime. In fact, there was a prosecution, Yamashita versus Tyre. That's a prosecution for war crimes. Hence, Your Honor, that's the reason why if the state is not doing its primary duty to investigate international crimes, then the ICC will come in order to prevent impunity. That's why the question is just simple. Has there been investigations or prosecutions for crimes against humanity, which is actually a crime under RA 9851. I think Section 7. Has there been actual investigations on crimes against humanity that occurred on the Philippine territory from November 1, 2011 up to March 16, 2019? And you can determine that for yourselves. The resounding answer is none. Therefore, Your Honor, the ICC is not a supranational court. It's not a world justice system that will look whether or not you're unwilling or unable, Your Honor. Last, Your Honor. In fact, Your Honor, even non-state parties can actually recognize the ICC's jurisdiction. That's under Article 12, Paragraph 3 of the ICC Rome Statute. In fact, Ukraine, it's not a state party. And yet it referred its situation to the ICC. Hence, there was an arrest warrant for Vladimir Putin. Lastly, Your Honor, the Philippines has been at the forefront of the international justice system. In fact, Your Honor, the Philippines actually contributed to international criminal law in Yamashita versus Thayer, the doctrine of command responsibility. That's because of Philippine jurisprudence. And Your Honors, there's actually a very famous concurring and dissenting opinion by Justice Gregorio Perfecto, and I want to read it on the records. He said that in the violation of the law of nations, the offended party is the people of the whole world, and the case against petitioner could be properly entitled as Humanity versus Tomoyuki Yamashita. And no person in position to prosecute the violators can honestly shirk the responsibility of relentlessly prosecuting them, lest he be branded with the stigma of complicity. Your Honors, our appeal is to also look at it from the viewpoint of the victims, mga balo po, mga anak, mga kapatid, mga ina, mga ama na nawalan po ng kanilang mga mahal sa buhay dahil po sa EJK, sa war on drugs. All they're asking is justice. And since it's a fact they did not get justice from the previous administrations, they're asking it from the ICC. And we hope that this August body will really ask the Philippines to cooperate with the ICC for the sake of justice. Maraming salamat po.